You are welcome to today's presentation. In today's presentation, we'll be looking at preliminary offenses of attempt and conspiracy. These offenses are classified as preliminary because it involves a situation in which the offender has not committed a substantive offense, a main offense. In the case of attempt, the offender has not committed the main offense, but he has taken sufficient steps to evince an intention to commit a particular offense. But his efforts at committing that offense just fall short of meeting the level of the main offense. So to that extent, the offense of attempt is described as preliminary or inchoate offense. Similarly, the offense of conspiracy is also referred to as a preliminary or inchoate offense. Preliminary and inchoate in the sense that the offense of conspiracy involves a situation in which two or more persons forms an agreement to carry out an unlawful purpose. Now, the moment they reach that agreement, the moment there is a consensus ad idem between the parties to commit what constitutes an offense, that agreement itself is an offense, irrespective of whether they later go on to actually carry out their joint criminal enterprise. Of course, if the subsequent to the agreement commits the intended offense, then they may be charged for both conspiracy and committing the substantive offense. So today's lecture is focused on the law relating to the offense of attempt. I'm going to share my slides, and then we can take it on from there. What is the learning objectives for today's presentation? The presentation will examine the law relating to the offense of attempt. And at the end of the lecture presentation, we expect that students should be able to understand the ingredients of the offense of attempt, particularly the mens rea and the actus reus of the offense, as established by statutory and judicial authorities. The students should also be able to understand the various tests that have been developed to determine whether the actus reus of the offense of attempt is constituted. And the students should also be able to understand the rules relating to the effect of legal and physical impossibility in the law of attempt, and when a defendant abandons his criminal enterprise. The learning outcome. At the end of the presentation, we expect that students should be able to explain the ingredients of the offense of attempt, particularly the mens rea and the actus reus of the offense as established by statutory and judicial authorities. We also expect that students should be able to explain the various tests that have been developed to determine whether the actus reus of the offense of attempt is constituted. We expect also that students should be able to explain the rules relating to the effect of legal and physical impossibility in the law of attempt, and when a defendant abandons his criminal enterprise. And we expect that students will be able to use the knowledge of the ingredients of the offense of attempt to answer problems or essay questions on the law of attempt. Now, describing the problem in the law of attempt. What is the basic problem in the law of attempt? The basic problem in the law of attempt is to determine at what stage in all the processes and steps that leads towards the commission of an offense, we can say confidently that the offender has reached the level of attempting to commit an offense. Now, you can imagine a situation in which Mr. A desires to assassinate the president, and he puts into motion a series of activities designed to achieve that objective. Number one, he buys a gun and obtains a license for the gun. He goes through shooting practice trying to learn how to use the gun over a couple of weeks. Now, after learning how to shoot and shoot accurately, he now stakes out the route that Mr. President normally takes every day from his home to his office. And he finds a convenient spot on top of a tree where he can hide and aim at the president whenever he's ready to assassinate the president. So he selects a particular date. And on that particular day, he left his house, carried his gun, climbed on top of the tree, waiting for the Mr. President to pass through that road on his way to his office. Now, unknown to him, Mr. President had traveled the night before. And Mr. President expects to come back, a short trip, expects to come back later in the day. So at the appointed time when the president is supposed to go to office, he sends his driver and his usual entourage to go to the office and wait for him. And when he arrives at the airport, he will call them to come and pick him up at the airport. So this Mr. A climbs the tree, waiting for the Mr. President, to ply the road and get to his office. And at the appointed time, the vehicle appears. Unknown to him, of course, the vehicles have tinted glasses, so there was no way for him to know whether Mr. President is sitting in the vehicle or not. Now, if at the point at which he aims at the Mr. President, he is arrested at that point before he fires a shot, that's one scenario. The second scenario is that he actually fires some shots at Mr. President's vehicle, and the shots broke the window of the glass in the rear seat where the president usually sits. But fortunately, Mr. President is not there. So if you look at this scenario, at what stage of all his elaborate plans can we say that Mr. A has committed the offense of attempting to kill the president? Certainly, it cannot be at the point at which he buys a gun, because at that point, nobody can say precisely what he intends to do with the gun. It certainly cannot be at the time when he begins to learn how to use the firearm, because even at that point, nobody can say categorically what his actions were aimed at achieving. Now, it gets a little bit more trickier when it gets to the point at which he climbs the trees and positions himself waiting for Mr. President. Now, if at that point, before firing any shot, before Mr. President appears, is arrested at that point, it is still not very clear what his intentions are. It's still not very clear. But at the point at which he fires at he shoots at the president. Now, whether the gun hits, the bullet hits the glasses, the windows of the president's car or not, at the point at which he aims at the president's car and fires a shot, certainly at that point, one can say with some level of assurance that he has reached the level of attempt. All the previous steps that he had been taking has been described in the cases as mere preparatory acts, which is not sufficient for the offense of attempt. Now, if he shoots at the president, misses the target, that may be sufficient to establish the offense of attempted murder. Even if the bullet breaks the glass, unfortunately, because Mr. President has traveled, there was nobody, on the rear seat. That will also support the fact that he has actually moved beyond merely preparatory act and has reached the level of an attempt. So that is the basic problem in the law of attempt. So the question usually is, within the series of preparatory acts that the offender is taking to actualize his objective of committing an offense, at what point precisely can we say that the offender has committed, has done, has taken sufficient steps to commit the offense of attempt? Now, what is the policy behind the criminalization of attempt? The policy behind the criminalization of attempt is very clear. Where an offender intending to commit an offense takes several steps to actualize his objective, and those steps have moved beyond merely preparatory acts, and those steps point to the fact that he actually intended to commit the offense, and he has taken some steps directed towards the commission of the offense. If for any reason he falls short in his attempt to commit the offense, the law takes it that having intended to commit the offense, having taken sufficient steps to manifest his intention, that is a sufficient threshold to hold him liable for the offense of attempt. Of course, the offense of attempt is a lesser offense compared to the substantive offense. Lesser offense in terms of punishment, because usually, as we'll see later, the law usually imposes half of the punishment for the substantive offense for an offender who has committed the offense of attempt. So that is the policy behind the criminalization of attempt. Once an offender intends to commit an offense, it moves beyond the level of intent. It begins to take specific preparatory steps towards actualizing his criminal intent, and he has taken sufficient steps as to clearly manifest his intention to commit that offense. Even if he falls short of committing the offense, the law takes it that there is sufficient evidence, there is sufficient justification to hold him liable for the offense of attempt. The offense of attempt is provided for in Section 4 of the Criminal Code, and Section 95 of the Penal Code governs the offense of attempt. Section 4 of the Criminal Code defines what constitutes attempt, whereas Section 95 is not that descriptive. It merely punishes the offense of attempt without making any elaborate effort to, list out what constitutes the element of the offense of attempt compared to Section 4 of the Criminal Code. Now, the first ingredient in the offense of attempt, which the prosecution has the burden of establishing, is the intent to commit a crime. And this is very critical. The prosecution must establish from the facts that the defendant intended to commit the offense that is accused of attempting to commit. Of course, we know that the court is not going to cut open the heart of the offender to determine his intention. The court will look at the circumstances of the case. The prosecution will lead evidence as to the circumstances of the case. And from the circumstances of the case, the prosecution will be able to establish whether we can say indeed that the offender intended to commit an offense. And if he intends to commit an offense, coupled with other ingredients of the offense, then that will be very critical. And we can see the importance of the prosecution establishing the intent of the offender to commit the offense in the two cases of Aran Seidu and Aran Ofion. In Aran Seidu, there was the case of the offender who carried a young girl, on his laps. And it was found that there was semen around his laps. So apparently, he must have been deriving some kind of sexual pleasure by placing the young girl on his laps. But the court said that clearly there was no intention on his part to commit the offense of rape, because he had not, done anything at all to signify that intention. We can also see the case of Aran Ofion, where the offender entered into the room of a lady uninvited and took off his clothes and invited the lady to have sexual intercourse. And the court said that those facts were not sufficient to establish the offense of attempt to rape, because there was no evidence that the offender tried to use force to have unlawful carnal knowledge of the lady. So the circumstances were not as such as to sufficiently establish an intention on the part of the offender to have unlawful carnal knowledge of the lady without, her consent. If there had been evidence of him trying to pin the lady down or try to forcefully remove her clothes and some other acts directed in that direction, the court will probably have been able to hold that there was intention to use force, to have unlawful sexual intercourse with the lady. And so the court came to the conclusion that there was no offense of attempt. Now, defendant must intend to commit an offense. There must be evidence that the defendant intended to commit an offense. Defendant cannot be guilty of attempting to commit a crime, which can only be committed recklessly or negligently. Of course, we know that in the criminal law, there are different levels of fault that the law may require as a basis for holding an offender liable. Intention is one of such fault element. Recklessness is one of such fault element. Negligence is one of such fault element. But in this instance, we are saying that for an offense of attempt to be constituted, it can only be in relation to an offense for which the defendant had an intention, and not an offense that can be committed recklessly or negligently. There are a couple of offenses that can be committed recklessly or negligently. For those category of offenses, you cannot charge an offender for attempting to commit those offenses recklessly or negligently. There must be an intent to commit a crime. In Aaron and Albert, the court held that intent to cause grievous bodily harm is sufficient for murder, but it is not sufficient to convict for attempted murder. There must be intention to kill. So the point in Aaron Albert is that, of course, we'll get to find out later that for the offense of murder, the offender must intend to kill the victim or must intend to cause grievous bodily harm. Okay? But for the offense of attempted murder, it is not sufficient if all that the offender had was an intent to cause grievous bodily harm. The prosecution must prove that the offender, intended to kill. And if fortunately for him or fortunately for the victim, he did not succeed in achieving his intention of killing the victim, then he can be charged with the offense of attempted murder. So, but mere intention to cause grievous bodily harm is not sufficient for the offense of attempted murder. The criminal code requires, now, the second element of the offense of attempt is commencement of execution. After the intention, then the offender must have gone beyond merely intending to commit the offense. He must have commenced the execution. He must have begun to take certain steps towards realization of his intention. So the second element is the commencement of execution. The criminal code requires that the offender must have taken steps towards the offense. It requires that the offender must have done the following: begun to put his intention into execution by means adapted to his fulfillment. The offender must have begun to put his intention into execution by means adapted to his fulfillment. He must not have fulfilled his intention to such an extent as to commit the offense. Now, if he has fulfilled his intention to such an extent as to commit the offense, then we can no longer be talking of attempt. The attempt has already merged with the substantive offense, and then in that case, the prosecution will charge him with substantive offense. Somebody who poisoned, an offender who poisoned the victim, and the victim survives, then the offender can be charged with attempted murder, because by poisoning the victim, we can deduce an intention to kill. Okay? But if the victim eventually dies, then we can no longer be talking about attempt. Okay, so the offender must not have fulfilled his intention to such an extent as to commit the offense. If he has fulfilled his intention to such an extent as to commit the offense, then he will be liable to be charged for the substantive offense. And he must have manifested his intention by some overt act. There must be some clear steps that the offender has taken, which shows us what his intention was. So once he has reached that stage, then we can say that the offender will be liable for the offense of attempt. But the real problem here is to determine at what stage the accused person can be held liable for attempting to commit an offense. Certainly, we can't hold him liable at the level of intention. Okay? Certainly, we can all hold him at the level where he begins to put his intention into execution, because at that stage, he's still at the preparatory stage. Okay? But certainly, we can hold him responsible at the moment he manifests his intention by some overt act. By the time he has taken some clear, visible steps showing us what his intentions are, but yet still falls short of committing the full offense, then at that stage, we can hold him responsible. Now, in the cases, you'll find that the courts have drawn a distinction between preparation to commit an offense and an attempt. In other words, where he begins to put his intention into execution by means adapted to his fulfillment. If he only stops at that stage, then we can say that that is still preparatory. In the case of the person who wanted to assassinate the president, we saw the various preparatory acts, that he took. Okay? Now, in our and Button, that's an English case, where the offender, enlisted to contest in a race. And it signified in his application, to contest in that race, that he has never won a race before. And he contested the race and won the race. But he had not yet collected the prize for winning the race. Of course, if he had collected the prize for winning the race, then the substantive offense of obtaining by false pretenses would have been completed. So at the moment at which he contested for the race and won the race, he was arrested. And the court said that at that stage, he had done all the, he had taken all the steps sufficient to constitute the offense of attempting to obtain by false pretenses. There's also the case of R. Robinson, where the offender hid his jewelry, tied himself up, and pretended that, his property has been burgled, and the people who burgled his property tied him up. Now, he was arrested at that stage, and the court held that, look, the actions he took were still a preparatory act. R. Robinson, the action he took was still preparatory act. He had not gone ahead to ask the insurance money to pay the insured sum on the jewelries, which he claimed to have been stolen. So the step that he had taken at that point was still said to be mere preparatory act. He had not gone beyond mere preparatory act. He has not sufficiently, if you want to use the language of the criminal code, manifested his intention by some overt act. The law sometimes criminalizes preparation to commit an offense. Okay? Although We have said that the law draws a distinction between preparation to commit an offense and an attempt. Where all the acts of the offender were merely preparatory, then no attempt. But sometimes the law criminalizes preparation to commit an offense. For instance, in Section 480 of the Criminal Code, the law criminalizes the offense of preparation for forgery. You can see the case of R and Nakanju. The law also criminalizes the preparation to commit crimes with explosives. So if a person is preparing to commit crimes with explosives, that can be an offense as provided by the law. Now, the courts or writers have suggested some tests for determining whether attempt has been committed and for determining whether the acts or the steps taken by the offender has moved beyond merely preparatory acts. You know, we said the courts have drawn a distinction between preparatory acts and an attempt, where what the offender has done is determined to be merely preparatory acts, then there's no attempt. So some tests have been suggested for determining whether an attempt has been committed and whether the offender has taken more than merely preparatory act. The first of such tests is a proximity test, which was formulated by Park B in the case of R and Eagleton. R and Eagleton. And the test is as follows. Some act is required, and we do not think that all acts towards committing a misdemeanor are indictable. Acts remotely leading towards the commission of offenses are not to be considered as attempts to commit it. Acts leading remotely towards the commission of offense are not to be considered as attempts to commit it, but acts immediately connected with it are. Now, in the scenario I gave earlier of the young man trying to assassinate the president, all those acts of him buying a gun, getting a license, learning how to shoot, perfecting his act of shooting, those are merely acts remotely. They are remotely leading towards the commission of the offense. Okay? They are not acts that are immediately connected with it. From that scenario example that I gave, they are acts that are immediately connected with his attempt, his intention to assassinate, is when he climbed the tree, positioned himself, and waits for the president, to pass through the road for him to have an opportunity to shoot at the president. Those are the acts that are immediately connected. And then, of course, by the time he begins to, shoot at the president, those are the acts that are immediately connected with his plan. So the court said, if the steps taken by the offender are remotely connected towards the commission of the offense, then they are not sufficient. There must be acts that are immediately connected, acts that are proximate, acts that are very close to the main offense, acts that are proximate. Proximate means something that is very close. For the application of the proximity test, see the case of Comer and Bloomfield. Now, in the case of Comer and Bloomfield, a man insured his van and pretended as if the van has been stolen and inquired whether he can claim the insurance money on the van. Now, at that point, he had not taken acts that are immediately connected with the offense. If he had gone ahead to claim the insurance money, he was only, at this point, he was only making inquiries whether he can claim the insurance money. If he had gone ahead to submit a formal request to be paid the insurance money on the insured van, then that will be acts immediately connected with the offense. of trying to obtain by false pretenses. We can compare that with the case of DPP and Stonehouse. Now, in DPP and Stonehouse, the defendant insured his life and he traveled to the United States of America and simulated death by drowning. He tried to arrange a scenario and portrayed himself as having drowned. Now, his intention was to enable his wife to claim on the life insurance money on his life. And the court said, look, in this instance, by simulating drowning, he had done everything that was necessary to be done that made his conduct to be proximate with the offense. All that the wife needed to do now was to claim the insurance money. Everything that he needed to do to create that deception, he had already done it by simulating that he had drowned. And then the news will spread. And then the wife will be able to claim the insurance money. He had done everything he needed to do to prepare ground for that insurance money to be fraudulently paid to his wife. So he was held liable for attempting to obtain by false pretenses there, because his acts are immediately connected with the offense for which is found liable for attempting to commit. The dictum of Part B in R and Eagleton was approved in Orija and IGP, the Nigerian case of Orija and IGP, and it has also been approved in other cases such as Jegede and the state. Now, the objection against the proximity test is that it is vague, because there was no clear indication when acts passed over from being remote to being immediately connected with the intended offense. It's good to say that when acts are remotely leading to the offense, then they are not sufficient to constitute attempt. But it's only when acts are immediately connected, when they are proximate. So how do we determine what is remote and what is proximate? So the test has been criticized on that ground. Then a writer, Turner, has also suggested a test. And he stated that if the acts of the accused, beyond reasonable doubt, indicate only that he intended to commit a certain definite crime, then he has performed a sufficient actus reus to support a charge of attempting to commit that crime. In other words, it seems to be saying that if the acts of the accused person indicate beyond reasonable doubt what his intentions are, then we can say that that is sufficient for attempt. And he likened it to a situation in which, you know, a cinematographic film is projected and all the various acts of the accused person, you know, are displayed on the film. And then the film is stopped suddenly and we are asked, what is this man trying to do? If we can say beyond reasonable doubt the end to which his actions are directed, then he has reached the stage of attempt. In the example that I gave earlier, the young man trying to assassinate the president. Imagine if all that story were reduced into a video, and you see the video of the man who went to go and buy a gun and is, you know, learning how to shoot the gun. If you stop the video at that point and somebody asks you, what do you think that this man is trying to do? There's no way anybody can say that the man is trying to prepare to assassinate the president. But if the video continues, after he has perfected his ability to shoot, and then you see him going to the location of the road where the president passes every morning, you see him climb the tree and come down. If we stop the video at that stage, there's no way anybody will know that he's planning to kill the president. But if on the day of the incident, we are still watching the video, he climbs on the tree, positions himself, and then suddenly we hear the siren of the president's vehicle approaching, you know, and then the guy, you know, positions himself, steadies his gun, you know, begins to adjust the telescopic sight towards the direction where the president is coming from. If we stop the film at that point, showing the president's, you know, entourage already appearing in the horizon, moving towards the line of contact, it is likely that somebody may suspect that, oh, it looks as if this guy is trying to assassinate the president. And then now imagine a situation in which the president's vehicle was already in his line of fire and he begins to shoot and the camera is stopped and somebody is asked, what do you think is trying to happen there? Of course, it will be clear at that point that beyond reasonable doubt that this guy is certainly trying to commit the offense of killing the president. So that's the sense in which Turner's, you know, explain his test. Turner's test has also been described as a cinematographic or equivocality test. Equivocality test to the extent that if looking at the circumstances of the case, all the preparatory act, we can say unequivocally that this is what the offender is trying to achieve. We can say clearly without, you know, doubting whether this is what he wants to do or that is what he wants to do. If we can fairly come to a position, if it is clear, if it is manifestly clear, just like the provisions of the criminal code say, if it manifests its intention by some overt act, overt is something that is manifest, something that is visible, something that we can see, something that is unequivocal, then we can say that, oh yes, this man is liable for the offense of attempt. A similar test was adopted by Smith J. in Orija and IGP, Supra, and the test was stated as follows. The prosecution must prove that the steps taken by the accused must have reached the point where they indicate beyond reasonable doubt what was the end to which they were directed. So we can see that this is also similar to Turner's test. You know, the question is, the steps taken by the offender, have they reached the point where they indicate beyond reasonable doubt? We have no doubt in our mind what his intentions are. In the case that, in the scenario that I gave earlier, by the time the guy climbs the tree, the president vehicle appears on the horizon, moves to the line of target, and he begins to shoot at the president, it becomes clear. Even if he misses at that point, it becomes clear what is, you know, beyond reasonable doubt, what was the end to which his actions were directed. And at that point, we can confidently say that the offender is liable for the offense of attempt. Okongo and Nash submitted that the draftsman of Section 4 of the Criminal Code probably had the equivocality theory in mind, because the Criminal Code says that the offender has begun to take steps and he manifests his intention by some overt act. You know, so that in a way is similar to the equivocality test. In other words, by the time he manifests his intention with overt act, it becomes clear, there's no doubt that this is what the offender had in mind. It is difficult to formulate a general theory or test of attempt that will be applicable in all cases. But the important thing is to bear in mind the policy of attempt. What is the policy behind the law of attempt in interpreting Section 4? And the policy is, if the offender has taken enough steps to clearly evidence an intention to commit an offense, even if he has not committed the main offense, at the level at which we are sufficiently sure that the various steps or acts he has taken are directed towards achieving a particular criminal intention, then at that point, we can hold him responsible for attempt. Now, we are going to be looking at incompletion of the offense independent of the perpetrator's will. there are certain circumstances that makes it impossible for the offender to be able to carry out his intention. And what would then be the legal position where the offender, even though he had intention, he had taken the preparatory steps, he had manifested his intention with an overt act, he has taken all the steps. We are clear in our mind that this is what his objectives are, but yet falls short of committing, of achieving his intention. What will be the legal position? Now, this is dealt with in Section 4 of the Criminal Code. Section 4 of the Criminal Code makes provision for 4 immaterialities. In other words, makes provision for 4 circumstances that will be immaterial to the offender's liability, even if he is unable to carry out his intention. And the first one is, it is immaterial except so far as regards punishment, whether the offender does all that is necessary on his part for completing the commission of the offense. Now, like we have said earlier, the moment he does all that is necessary to complete the commission of the offense, then we can no longer be talking of attempt. We have moved into the realm of the substantive offense. So if all that happens is that the offender has not done everything necessary to complete the offense, then that cannot be a defense to liability. If he has taken sufficient steps to manifest his intention, then it is immaterial that he has not completed the main offense. And in any case, like we said, if he has taken steps to complete the requirement for the offense, then we can no longer be talking about attempt. He will be charged with the substantive offense. Then the second immateriality is whether the complete fulfillment of his intention is prevented by circumstances independent of his will. In other words, his inability to complete the offense is not as a result of his own fault. For instance, in the example that I gave, the young man who wanted to assassinate the president did not know that the president has traveled. He did not even know that the president was not in the car. All he did was to shoot at the car. And he shot at the place where the president normally sits, in the rear seat. The bullet breaks the window and will have hit the president if the president had been sitting there. But the president was not there. So the fulfillment of his intention is prevented by circumstances independent of his will. He didn't know that the president was not going to be there, but that will not, make him to escape from liability for attempting to kill the president. Even though the president was not in the car, he has manifested his intention sufficiently to show that he intended to kill the president. Even though he shot at an empty car, he can be prosecuted for the offense of attempting to kill the president. The third immateriality is whether he desists of his own motion from the further prosecution of his intention. Now, if the offender had taken sufficient steps to manifest his intention to commit the offense, and then he suddenly changes his mind, but provided he has taken sufficient steps and he has manifested his intention by an overt act, he had already reached the level of attempt. So even if at that point he stops from moving ahead to complete the offense, he will still be liable for the offense of attempt. The only thing is that because he desisted of his own motion, he was the one that stopped the further prosecution of the offense on his own motion, not because of any circumstance. Because of that, the court may take that into consideration in the quantum of punishment that may be awarded or imposed on the offender. But certainly, the moment he has taken sufficient steps, he has manifested his intention by an overt act, the level of attempt has already been reached, the offense has already been committed. Even if at that point, it stops from going ahead to complete the offense, is liable for the offense of attempt. The only thing is that the fact that he desisted of his own motion may go towards mitigating his punishment. And then the fourth immateriality. It is immaterial that by reason of circumstances not known to the offender, it is impossible, in fact, to commit the offense. Okay? Maybe let's even take a situation in which, maybe unknown to him, the president had died the previous night. The president had died the previous night. And the state authorities were only waiting till daybreak, a little later in the morning, to break the news to the entire nation. So they still just wanted to, the president entourage were asked to go to the president's office so that the VP and everybody will be there before they make the announcement. And the offender who wanted to kill the president, unknown to him that the president is already dead, shoots at the president's vehicle. It's impossible to kill a man who is already dead. So it is immaterial that by reason of circumstances not known to the offender, it is impossible, in fact, to commit the offense. Now, what is the meaning of circumstances in Section 4? The Criminal Code does not provide any definition of the word circumstances in Section 4. And Okonkwo and Naj's view is that it means physical as opposed to legal circumstances. In other words, the argument is that if it is legally impossible to commit the offense, then a person cannot be held liable for attempting to commit an offense that is not legally possible. For instance, if a property is mine, if something is mine, but unknown to me, I did not know that it's mine. Let's assume I have an Apple phone, and the Apple phone was stolen, and I've been looking for money to buy another Apple phone, and I didn't get money to buy it. And a couple of days later, I saw somebody's Apple phone placed carelessly in a public event, and I used the opportunity to steal that person's Apple phone, or I attempt to steal that person's Apple phone, and I was caught in the process. As I grabbed it, trying to pull it away, the phone dropped in my hand, and it was clear to everybody that I had attempted to steal it. Now, if it later turns out that it was actually my phone that was stolen, that was given to the person who brought it to that public event, now, legally, it is impossible for me to steal something that is mine. Because the phone is mine. There's no way I can be convicted of attempting to steal my own phone. But at the time I wanted to steal it, there was no way of my knowing that it was my phone. But it later turned out that when they now checked the serial number and all the IME number and all that, it turned out it was actually my phone. At that point, the prosecution cannot maintain a charge of attempting to steal the phone against me, because that was a case of legal impossibility. There's no way I can be held liable for attempting to steal my own phone. So Okonkwo and Nash argue that the word circumstance, as used in those immateriality provisions of Section 4 of the code, should mean legal circumstances. So where there is physical impossibility, then there is attempt. Okay? The fact that the president was not in the vehicle when the person who wanted to kill the president shot at the vehicle, that's a case of physical impossibility. he will be liable for attempting to kill the president. But in the example that I've just given now, there is no way I can be liable for attempting to steal the phone, which turned out to be mine, because that is legal impossibility. Because one of the things that has to be shown is that I tried to steal a property belonging to another person. But that property did not belong to the person in whose custody it was at the time I attempted to steal it. The property actually belonged to me. Okay? Now, we now want to look at what the cases have to say on non-legal or physical impossibility. Non-legal or physical impossibility. Non-legal or physical impossibility. Non-legal or physical impossibility. This is where it is physically impossible for the defendant to commit the complete crime, whatever means he adopts. It is physically impossible for the offender to commit the complete crime, whatever means he adopts. Now, in the case of R and Link, the defendants were trying to pick pockets, but it turned out that there was nothing in those pockets. Okay? So like somebody dips his hand into your pocket, hoping that you had money, and you were able to grab his hand. And it turned out that unfortunately there was no money on the side of the pocket where he had dipped his hand. He will be convicted of the offense of attempting to steal, irrespective of the fact that there was no money in the pocket. That's a case of physical impossibility. There's also the case of R and Bailey and Easterbrook. You know, the defendants broke into a box, hoping to steal from it. Unknown to them, the box did not contain anything valuable. So they were convicted of attempting to steal from the box. There's also the case of impossibility through ineptitude. This is where the crime is impossible in the circumstance because of the defendant's ineptitude, inefficiency, or his adoption of insufficient means. Okay, like in R and White, the defendant wanted to kill his mom, puts poison into a drink, but the poison was not sufficient, to achieve the purpose. And the mom survived. So, although the offender was lucky, because if the mom had died, he would have been liable, to be charged for the offense of murder. But in this instance, the fact that he puts insufficient dose of the poison does not detract from his liability for attempting to kill his mom. You can also see the case of R against Farad. And then there's also a case of non-legal physical impossibility through abandonment. Now, it is immaterial whether defendant voluntarily abandoned his enterprise if he had reached the state of attempt. I said something like that earlier. If the offender had taken preparatory steps and he has manifested his intention by an overt act to the extent that the offense of attempt is already committed, even if he abandons the continuation of his steps towards committing the main offense, the offense of attempt has already been committed. For instance, in the case of R and Taylor, the defendant approached a stack of corn and he wanted to set fire to them. And he lighted a match. Now, after lighting the match, he now suddenly discovered that some people were looking at him. He thought he was alone. And then he now did not go ahead to set the stack of corn on fire. Now, you will agree with me that he has already taken sufficient steps to manifest his intention. If he had not lighted a match before seeing that people were watching it, and he just cleverly moved away. Nobody will even have known what his intentions were. He will not have manifested his intention by an overt act. Because you will just think, even if you had seen him looking at this stack of corn suspiciously, you probably may be thinking, is he planning to steal it? Or what are his intentions? So you wouldn't know that his intention was to set fire to it. But when he brought out a match and lighted the match, that clearly evinces an intention to set the corn ablaze. And the fact that he now saw people and decided to abandon his criminal enterprise is of no moment. He had already gone ahead and reached the state of attempt. He had formed an intention to set the corn ablaze. He had taken preparatory steps by walking towards the location of the stack of corn. And he had manifested his intention by lighting a match and was only about to throw it at the corn, which would have been the main offense of setting the corn ablaze. So by walking away, although he desisted of his own motion, that is of no moment. The offense of attempt is already completed. But you can see this, the provision of section 512 of the Criminal Code. If the offender, however, desisted of his own motion, the court may take that into consideration in the quantum of sanction, the quantum of punishment that the court may impose. Because the fact that he voluntarily changed his mind. In fact, in the case of Aaron Taylor, we can't even say he voluntarily changed his mind. His change of mind there is not out of any altruistic objective. He didn't change his mind because he suddenly realized that, what I'm about to do is bad, or I shouldn't be doing it. No, he changed his mind because he knew that there are people watching him, and the police will apprehend him for setting the corn on fire. So in this kind of a situation, he will not even be entitled to any, leniency in terms of punishment under the provision of section 512. But section 512 provides that in appropriate case where the offender voluntarily stopped or abandoned his enterprise, then that offender, the court can take that into consideration in the quantum of punishment that the court may want to impose. Now, there's a case of legal impossibility. I had said something about that earlier, and I gave the example of attempting to steal a phone that is actually mine, which at that point, I did not know it was mine. But it later turned out after I was apprehended for attempting to steal it, that the phone actually belonged to me. That is a case of legal impossibility. There's no way I can be charged for attempting to steal my own phone. Now, in England, before section 1, 2, and 3 of the Criminal Attempts Act of 1981, there is no offense of attempt where it is legally impossible to commit the offense. So where it is legally impossible to commit an offense, then there can be no offense of attempt. Because, how can a person be found liable for committing what is legally impossible? You can see the case of Houghton and Smith. In that case, the defendant was charged with attempting to handle stolen goods. But unknown to the defendant, the goods were no longer stolen because the police had commandeered the van in which the goods, were kept. So because the police was already in control of the goods were no longer stolen goods. Even though the defendant clearly intended to deal in the stolen goods. So that was a case of legal impossibility. But the Law Commission in England recommended that the emphasis should be on the intention of the accused, provided there was proof of more than merely preparatory act. The recommendation was contained in section 1, 2, and 3 of the Criminal Attempts Act of 1981 and was applied in the case of R and Chief Puri. Now, in that case, the defendant was convicted of attempt to be knowingly concerned in dealing with prohibited drugs. Although what the defendant believed he was dealing with turned out not to be drugs. The defendant thought he was dealing, he intended to deal in prohibited goods. But what the defendant actually was dealing with was not drugs. But despite the fact that the drugs were not prohibited drugs, which was a case of legal impossibility, because the law had been amended in England, the defendant was convicted. The defendant was convicted of this offense. Now, the question then will be, a defendant is convicted for doing something that is legally impossible. What is the rationale? What is the justification to convict a person of doing what is legally impossible? I mean, in that example that I gave earlier, where I attempted to steal my own food, what wrong have I committed for attempting to steal my own food? Even if I had intended to steal, but the reality is that the phone is mine. So there's no legal wrong. Really, there's no legal wrong. So if there's no legal wrong, then it will appear as if the law is punishing the defendant for a moral wrong. So, I mean, I find it a little bit, I'm not too comfortable with the change in law in England. Because if I'm not doing a legal wrong, if what I'm doing is a moral wrong, yes, because I intended to steal that phone, that's morally wrong. Although the phone is mine. But I believe that moral wrong in this instance should be negated by the fact that it is not a legal wrong. The moral wrong should, in my view, not trump something that does not amount to a legal wrong. Because it is what amounts to a legal wrong, in my view, that should prevail. Yes, I tried to steal a phone. I tried to steal a phone. Let's forget for 1 minute that the phone is mine. By trying to steal that phone, that is morally wrong. But the facts later showed that the phone is mine. So that means even though I may be wrong morally, I've not done anything legally wrong. And if I've not done anything legally wrong, I should not just be punished based on the fact that I've done something that is morally wrong. In any case, the position in Nigeria is still the old common law position. If the thing is if it is legally impossible, then it shouldn't be it shouldn't be a crime of attempt. The punishment for attempt. The gravity of the punishment for attempt generally depends on whether the offense attempted is a misdemeanor, simple offense, or a felony. Offenders convicted of attempting to commit an offense punishable with death or imprisonment for 14 years is liable to imprisonment for 7 years if no other punishment is provided. So you can see that generally the punishment for an attempt is not as much as the punishment for the substantive offense. So if somebody commits is convicted of attempting to commit an offense punishable with death or imprisonment for 14 years, then such a person will be liable to be sentenced to 7 years imprisonment, provided that the law does not provide any other punishment. For other types of felonies, the offender is liable to half of the punishment of the offense. So for other types of felonies, the punishment of the offender for attempting to commit the offense is half of the punishment for the main offense. For misdemeanors and simple offenses, the offender is still liable to half of the punishment for the offense. Under the penal code, the offender is liable to half of the punishment for the offense. The criminal code makes provision for specific cases of attempt. There are some specific cases of attempts that the criminal code makes some specific provisions for. While the general principles relating to attempt under Section 4 applies to these specific cases. Other provisions may add other ingredients which the prosecution has to establish to sustain conviction. Also, the specific provisions usually stipulate the punishments, which are usually higher than the punishment stipulated for attempts generally. For instance, the punishment for attempted murder is life imprisonment under Section 320, without which the punishment under the general provision will have been 7 years imprisonment. Then you can also see Section 359 of the code for punishment for attempt to commit rape. So in these two instances, the law specifically provides, a more serious punishment for the offense of attempt, And when we get to look in the second semester, when we get to look at offenses under the Advanced Fee Fraud, another Special Offenses Act, we'll see that under the provisions of that law, attempts are sometimes punished with the same punishment for the substantive offense. We'll get to see that when we get there. All right, so thank you for your attention. So we have looked at the law relating to the offense of attempt. So I expect that you will take time to listen to this presentation and come prepared with your questions. And if there are any other aspects of the lecture that requires additional clarification, I'll be glad and willing to do so when we now meet in class physically. So thank you very much. Don't forget to subscribe to my YouTube channel so that as soon as I post, additional video materials, you'll be able to gain access to them instantly. Thank you very much. God bless.